We've recently moved to our new home, and we are webcasting to you from Deneen Hall. And we're very happy to have the Angela S. Cooney Professor of Law, Lisa A. Dolak. She's an expert in patent law. She's a professor here at the law school, and we're very pleased to have her here with us today to present on the Patent Trademark and Appeals Board contested proceedings, tips, traps, and pitfalls for the patent owner and petitioner. So without further ado, thank you very much, Professor Dolak.
Thanks very much, Molly. I've got a lot of slides, so I'm going to proceed quickly. I'm happy to try to take questions as we progress. First of all, I want to note that last summer we did a webinar entitled Patent Office Post-Grant Contested Proceedings, New Challenges, New Opportunities. And that's sort of fundamental background, introduction to these proceedings. And it's territory that I'm not going to cover much of again today anyway. And so I just thought I'd mention that it is available to you as a resource for that essential background. Just a tiny bit of quick review in terms of these patent trial and appeal board post-grant contested proceedings. We're talking about post-grant review, inter-parties review, and the post-grant review for covered business methods. And just to refresh your recollection, post-grant review is available only as to the so-called first inventor to file patents, those patents whose challenged claims have an effective filing date of March 16, 2013 or later. And even as to those patents, post-grant review is only available within the first 9 months after issue or reissue of the patent. So we haven't seen, to my knowledge, any post-grant review, certainly none instituted yet. These patents are just now beginning to come online, so we don't have a lot to learn yet about these. The standard for grant of the petition in a post-grant review, in other words, to institute the proceeding, is that the petition has to show that it is more likely than not that at least one challenged claim is unpatentable, or the petition has to raise a novel or unsettled legal question that is important to other patents or patent applications. When these proceedings are available, or when these begin, the grounds for attack is really any invalidity defense that's available under 35 U.S. Code Section 282, with the exception of double patenting. Double patenting is not a basis for challenging claims in post-grant review. Inter-parties review is available as to both non-first inventor to file patents, in other words, pre-AIA patents, as soon as they are issued, and as to first inventor to file patents after the window has closed for post-grant review, basically.
Please stand by. We're having a few technical difficulties that we hope to address shortly. Thanks.
Okay, sorry about that. I think we're good to go. All right, sorry about that. We're still working out the bugs here in Deneen Hall, although it is quite beautiful. Anyway, as to inter partes review available for the first inventor to file patents after post-grant review window has closed, or any post-grant review proceedings that have been instituted are over. The standard for grant of a petition in an inter partes review is that the petition has to show that there is a reasonable likelihood of prevailing on at least one challenged claim, but the grounds are limited to anticipation or obviousness based on patents or printed publications. The transitional program for covered business methods is available for patents that claim a method or corresponding apparatus for performing data processing or other operations for financial product or service. Patents that cover technological inventions are excluded. And these, the CBMs are available for any covered business method patent except for those first inventor to file patents during that first 9 months when they are susceptible to regular post-grant review. But there's a standing limitation for covered business methods that does not exist for inter partes review or post-grant review. These CBM proceedings can only be filed by petitioners who have been sued or charged with infringement of the patent at issue. The standard for the grant of the petition, these are fundamentally post-grant reviews, and so the standard is the same. More likely than not, there's an unpatentable claim. And the grounds are the same as PGR. I say here any invalidity ground. Two important exceptions: double patenting, just like PGR, and Section 102E prior art is not a basis for challenging a CBM. That's kind of a quirk in the AIA statute, and one that has not yet been fixed to the extent people think it needs to be fixed. Here's a little bit of statistical data. This is, as you can see, through June 30th of 2014, so a little over a month ago, there had been 1,405 petitions received, and you can see that the general trend has been an increase in the number of petitions that have been received by the USPTO. Covered business methods, fewer, only 186. Of course, again, there's the standing limitation, and the type of patents that can be challenged in covered business method review is more limited, but still a good number have been filed. Why are these proceedings so popular? Well, the claims are with challengers, that is, the claims are given their broadest reasonable interpretation, as opposed to the Phillips claim construction standard that's used in district court. There's no presumption of validity. The challenger need only succeed on a preponderance of the evidence standard. There's a very limited opportunity for claims to be amended. The estoppels that exist are limited for IPR and very limited for CBM. In the sense that, well, we'll talk about that in a moment. We'll come back to that. They are less expensive, although not cheap, as compared with district court challenges. These proceedings are statutorily required to be fast, and therefore they are coming in faster than district court challenges. If these proceedings are instituted, there is an improved chance that the courts will stay the concurrent litigation, and the statistics so far anyway have certainly favored the challengers. So what I want to do today with the time that we have is to focus not so much on what the statute and rules say, although to some extent we'll have to refer to the statute and rules, but primarily I tried to choose a few areas where we're learning some interesting things from the decisions, from the PTAB decisions, from district court decisions, and from federal circuit decisions. And so this is the subject matter we're going to cover in the next 50 or so minutes. The eligibility, in other words, petitioner eligibility, who can and under what circumstances bring these proceedings and On the contrary, when they are barred or stopped from bringing them or other proceedings. The patent owner preliminary response, the PTAB decision whether to institute review or not, claim amendments, and a few sort of miscellaneous things to wrap up with at the very end. So as to that first subject area, eligibility and bars, this is a review of the law. Inter partes review is barred if the petitioner or its so-called real party in interest, which I've abbreviated as RPI, I think for the rest of the slides, has filed a civil action challenging the validity of a claim of the patent, or if more than a year has passed since the petitioner, its RPI, or a privy has been served with an infringement claim. And except that a time-barred petitioner may ask to join another party's IPR within 1 month of its institution, according to the rules. PGR is barred if the petitioner or its real party in interest has filed a civil action challenging the validity of a claim of the patent, just like inter partes review. And CBM is also barred if the petitioner or its RPI has filed a civil action challenging the validity of a claim of the patent. CBM is also barred unless the petitioner, its RPI, or a privy has been charged with infringement under the patent. That's that standing requirement that I referred to. The main point of all that language on the last 3 slides is to point out 2 things: that there is this time bar for inter partes review that we'll be talking a little bit about, and that these various bars have the limitations that apply to the petitioner if its real party in, if it or its real party in interest has done certain things, or if the petitioner, its real party in interest, or a privy. So one of the things I want to talk about is what constitutes a real party in interest or a privy. Turning just by way of example to estoppels, and again, this is all kind of complicated and a lot of text to fit on a slide. I tried to boil it down as best I could. And of course, the ultimate source here is the language of the statute and the rules, and I'll refer you to that for precision. But the bottom line here is that a final written decision of the PTAB estops a petitioner in an IPR, and it will also estop the petitioner's real party in interest and its privies from raising in any subsequent USPTO, district court, or ITC proceeding any ground that the petitioner raised or reasonably could have raised in the IPR. So the estoppel extends to the petitioner, its RPI, and its privies. Similarly, in a PGR, the petitioner, its RPI and privies will be barred, will be estopped from raising in any subsequent USPTO, district court, or ITC proceeding any ground that the petitioner raised or reasonably could have raised in the PGR. And again, this is upon issuance of a final written decision of the PTAB. In a CBM, it's a little bit different. There's a different estoppel that will apply in future USPTO proceedings. A final written decision of the PTAB in a CBM will stop the petitioner, its RPI, and its privies from raising in any subsequent USPTO proceeding any ground that was raised or reasonably could have been raised in the CBM. But as to future district court or ITC proceedings, a CBM petitioner and its RPI are stopped from raising only grounds that were raised in the CBM. So this is what I mean by a very limited estoppel will apply to petitioners and their RPIs from coming out of CBMs in future district court or ITC proceedings. Another thing to note here, just by the way, these estoppels are by claim, not by patent. So what I want to do is just quickly look at what we've learned in the time that these proceedings have been ongoing about a number of issues: factors that govern joinder of these proceedings, what triggers the 1-year bar in an IPR, who is an RPI, who is a privy, and what does reasonably could have raised mean. As to the factors that govern joinder, this is just a very, very, sort of boiled down basic review. Joinder is a complicated thing. I note on the slide that a decision on a joinder motion is within the PTAB's discretion. The PTAB has indicated that it has the discretion even to ignore the 1 month deadline in terms of 1 month after institution. So there's a lot of discretionary things going on here. But just by way of example, you're more likely to succeed with a joinder motion. And basically everything you ask the PTAB to do is by motion. If the issues that are in your petition and the petition you're trying and the proceeding you're trying to join are identical, basically. But the greater the similarity and the greater the analyses, the more likely that the board will grant joinder. The board will look at the impact of a potential joinder on the schedule, because again, the statute says that these proceedings have to be completed within 1 year from institution, extendable up to an additional 6 months for good cause. But, and we're seeing the board really, being quite faithful and quite demanding of petitioners and patent owners with the goal toward meeting that statutory deadline. And then you can only join a proceeding that is still pending. So one thing that is a potential trap for petitioners, particularly petitioners who would otherwise be time barred and need to join another proceeding because of that 1 year bar, is they need to worry about the potential that the proceeding they're trying to join might have been terminated by the time the joinder is considered. So that's just a little bit of a summary on what we're learning about joinder so far. Turning to what triggers the 1 year IPR bar, we've learned a number of things from the PTAB. Now, I'll caution you, these PTAB decisions I'm citing, I think without exception today, I don't think any of them are so-called precedential. So the board is not bound by these rulings. But I think we've only had one precedential ruling by the board thus far, and it's recent, and I don't even think I'm covering it here today. But so you can cite these to the board, but they're not binding on the entire board. That's why I'm referring to these as guidance. The PTAB in the Samsung case that I cite here has indicated that the 1 year bar is triggered by complaints that were served in district court, even if those complaints were served before the AIA was even passed. So in other words, even before these proceedings were available, if you were sued and served in a civil action in a proceeding, and it's now, by the time you get around to filing your petition, more than a year has passed, too bad. The same is true. The 1 year bar is triggered and applies even if the petition you're filing is filed within 1 year of service of a second complaint. And that's this Apple case. The 1 year bar will apply even if the second complaint asserts infringement of claims that were amended in reexamination between the first complaint and the second complaint. So the board has been broadly construing the 1 year bar, I think, is the takeaway here. And I guess not too surprisingly, the 1 year bar is triggered by the service of a counterclaim for infringement as well as a claim for infringement. But it is important to note that the PTAB has, in a number of cases, interpreted the statute to say that if a complaint is dismissed without prejudice, it's as if that civil action never existed. Third topic under this eligibility bars and estoppels heading. What does real party in interest and privy mean? What do those terms mean? There's no definition in the statute. In the trial practice guide that was issued when the rules governing these proceedings was issued, the USPTO told us that it's a highly fact-dependent question, cited to the Supreme Court case of Taylor versus Sturgill from 2008, said that the PTAB will decide what and who is a real party in interest and a privy on a case-by-case basis, taking into account how courts have viewed the terms, and have indicated that courts invoke these terms to describe relationships and considerations sufficient to justify applying conventional principles of estoppel and preclusion. Furthermore, in the trial practice guide, the USPTO indicated that a real party in interest is the party that desires review of the patent, and that would include someone who pays a third party to file a petition, and someone who directs or controls the content of a petition. It further indicated that in its view, the concept of privity is even more expansive, encompassing parties that do not necessarily need to be identified as real parties in interest, and quoted the legislative history of the AIA, a statement that said that privity is essentially a shorthand statement that collateral estoppel is warranted. So that's what we learned before we even had any of these proceedings. Furthermore, the USPTO said that a common consideration is whether the non-party exercised or could have exercised control over a party's participation in a proceeding. Control, we have learned, has been very important here. The whole concept of control is what is governing these determinations by the PTAB. Now, of course, we'll have to see whether the courts, whether the Federal Circuit will ultimately agree with the USPTO's interpretation of the statute. So that's an open question. But on the battleground of the PTAB, even though control is only one factor from that Supreme Court decision that I referred to a moment ago, it has been the predominant factor, as we'll see in a moment. The USPTO further indicated that it is not enough without more that the petitioner belongs to a trade association which itself has filed a petition. And it's not enough that you merely belong to a joint defense group and another member of that group files a petition. That does not make you a real party in interest of that other petitioner or a privy. Without more. So the PTAB, here's what and I don't cite the decisions here. These are all out of decisions of the PTAB, though. The PTAB has now weighed in actual proceedings, and at least in the cases that I'm referring to here, the PTAB has held that without more, mere agreement by a co-defendant to be bound by a determination in an IPR is not sufficient. Sometimes we're seeing these agreements are being filed in courts in support of stay motions. And so we're seeing in situations involving co-defendants, sometimes one defendant will support a motion for a stay that's been filed by a co-defendant by agreeing that they'll be bound by whatever the PTAB has held. That does not make you, in the view of the PTAB, a real party in interest or a privy. PTAB has held that, again, without more, a supplier is not a privy of its customer, just because it's a supplier of its customer. Similarly, a customer is not a privy of its supplier without more. A litigation defendant is not a privy of the petitioner that was created as a result of its merger, and a litigation defendant is not a privy of its acquirer. So there's a lot of PTAB decisions on what constitutes a real party in interest in a privy. The board is tending to be pretty restrictive, and in other words, the result of the general trend of the board's determinations is to allow these petitions to move forward, to not impose bars where patent owners would like to see them being posed. So I would just highlight this as a potential tip for petitioners and a potential trap or pitfall for patent owners is patent owners are not getting as expansive interpretations of these terms as they, as a general matter, would like. Furthermore, the PTAB has held that the existence of an indemnification agreement between a supplier and a customer is probative of the opportunity for control by the supplier, but doesn't itself establish control. And has said in this particular case, control of the litigation or some sort of representation constitutes a crucial factor. And it is not enough for the patent owner to show the mere possibility that the petitioner controlled or could have controlled the district court litigation. And furthermore, paying for trial expenses pursuant to an indemnity does not normally establish privity or control. So again, a restrictive interpretation of these terms. And in this case, accordingly, even refused to grant the patent owner's motion for additional discovery to obtain the indemnity agreements obtain the indemnity agreements that were at issue. However, the PTAB has indicated that a petitioner's predecessor was its real party in interest, and it reached that conclusion applying Florida state successor liability law. So I chose this case to highlight that the PTAB will look to state law to determine in situations involving mergers and acquisitions and corporate succession. We'll look at state law in order to determine whether or not these requirements of real party and interest or privy are met. In this particular case, the PTAB found that the predecessor corporation and the petitioner basically operated as one continuous entity. Really nothing had changed. And so on that ground held that the predecessor was the same, essentially, the real party and interest in the subsequent petition. So some sort of advice for patent owners or tips for patent owners. Scott McEwen, who is an experienced expert in patent post-grant proceedings broadly, has suggested that where possible, patent owners ought to try to get these indemnification agreements in district court discovery because they're not going to be able to get them likely in PTAB discovery. And of course, again, we need to see how this all shakes out at the federal circuit. And so pending that, patent owners should raise real party and interest and privity challenges where appropriate, where they have a basis for doing so at the PTAB. For example, these issues can be raised in the patent owner's preliminary response in order to at least preserve the issue for appeal to the federal circuit. And then I'd note here that there is a PTAB decision that suggests that indicates that even if an indemnity obligation is sufficient to create the requisite control, that the sort of contractual existence of that potential obligation is not enough to signify that control or to establish that control. The indemnity obligation really only comes into existence when the party has been sued. And so the 1-year bar would run, or the time would start to run when that indemnity obligation was actually triggered by suit and not by the sort of pre-existing background indemnity obligation. So for petitioners, it's important to note, though, that agreements that convey the power to control the litigation decisions of other parties may create privity. This whole issue about opportunity for control versus actual control has not shaken out yet, even at the PTAB level. So petitioners need to be wary of and worried about and cognizant of the potential effects of agreements, indemnity agreements, and other kinds of agreements that convey the power to control the litigation decisions of others. Patent owners and petitioners should be aware that for purposes of that standing requirement to bring post-grant review challenges to covered business method patents, the legislative history of the AIA does suggest that a customer is a privy. So there's this little bit of a difference here, and that's why I highlight it. And specifically, Senator Schumer, during the run-up to the AIA, said that a privy is a party for purposes of CBM standing that has a direct relationship to the petitioner, and it effectively means a customer of the petitioner. Most important thing about this area as it develops for both patent owners and petitioners is that these questions about who constitutes a real party in interest or a privy are highly fact-dependent determinations. And of course, like all highly fact-dependent determinations, what might be perceived as a relatively minor change in the facts could change the outcome. The last area I want to talk about under this heading of estoppels is this statutory language that governs in IPRs and in PGRs, reasonably could have raised. Now, what does that mean is the question, because obviously that's the extent of the estoppel, the grounds that that the petitioner or its real party in interest or privies reasonably could have raised. In IPR, of course, you could only have raised anticipation or obviousness, and furthermore, only on patents and printed publications. So it would seem pretty clear that petitioners, real parties in interest, and their privies are not estopped as a result of a final written decision in an IPR from raising other non-cumulative prior art like on sale and public use grounds, because you couldn't have raised those in the IPR. You further would not be estopped by a final written decision in an IPR from raising non-prior art grounds like Section 101 or 112 grounds. But how exhaustive does as the petitioner, does your prior art search have to be? And so that's something that the courts are going to have to decide in terms of what does that mean, reasonably could have raised. Obviously, if the amount of resources that go into a prior art search will determine, in terms of time and money, will determine how much art and what art could be found. Senator Kyle, during the run-up to the AIA, said that reasonably ensures that could have raised estoppel extends only to that prior art which a skilled searcher conducting a diligent search reasonably could have expected to discover. But again, what does that mean? Well, we're going to have to wait and see. Courts will have to decide. In PGR and CBM, again, we have the same issue as above regarding print prior art. How exhaustive did your search have to be? Patent owners can be expected to argue that, well, you had, at least with regard to IPR, you had all the time in the world to prepare for the filing of the petition. I mean, subject to the 1-year bar, you had lots of time to prepare for it. Even in PGR, you have those first 9 months after issuance. So you had plenty of time, petitioner. You could have done a more exhaustive search, and therefore some piece of prior art that is raised subsequently reasonably could have been raised before. That's the issue that I'm really getting at. So, of course, petitioners will argue that they only needed to be reasonably diligent, according to Senator Kyle, and they had limits both in terms of the time available to them for filing PGR and if they had been sued in district court for filing an IPR. So these are the kinds of arguments that will be made. It is important to note, however, that because PGR and CBM are not limited to prior art grounds or to print prior art grounds, there is a potentially very broad estoppel because, again, Section 101 and Section 112 grounds may also be raised in PGR. A few other interesting estoppel questions that are going to have to be resolved. Estoppels are triggered, again, only by final written decisions of the PTAB. And so one question that we can anticipate coming up in stayed concurrent litigation, we can expect petitioners who, once the final written decision has been issued, we can expect petitioners who support stay to argue that the concurrent litigation should remain stayed until the Federal Circuit decides the case, since the Federal Circuit might overturn the decision of the PTAB and that any estoppel may potentially evaporate. Another open issue is, and this is a really interesting one, I think, which is a petitioner estopped from re-raising grounds that it included in its petition, but that the PTAB did not rely on in making an institution decision. And there are arguments on both sides of that, and that's about all I have time to say about it. But this is a question that's been kicking around since these proceedings began, and we're just going to have to wait and see. Turning now to the next item on the agenda, the patent owner preliminary response. Just a few things to say about this. First thing is, note that this is the thing that can be filed by the patent owner prior to the institution by the board. It's optional, though. The patent owner has the right to file a preliminary response, setting forth reasons why no inter-parties review or post-grant review should be instituted. But there is a limitation in the statute. The patent owner preliminary response is limited to a challenge based upon the failure of the petition to meet any requirement of the chapter. It is the case that so far in these post-grant proceedings that have been filed at the board, most patent owners have in fact filed patent owner preliminary responses. I think it's in the 60% range or so. There's also a time limit. The time limit for filing is no later than 3 months after the date of a notice, indicating that the petition has been granted a filing date. So that date of the notice starts the 3-month clock. Although the board can shorten that time, that's an important potential trap for patent owners. The board has the power to shorten that time. So patent owners have to be worried about that and pay attention to it. Patent owners have the right to expedite the whole process, the decision of the board on institution, by actually going on record and saying they elect to waive. So you have a choice as a patent owner. You can file one of these. You can just let the time pass for filing one and not take any affirmative action, or you can affirmatively waive the right to do it. And about 20% of patent owners have waived. And again, the goal there seems to be just to speed things along, because the board will act faster if it knows that there's no patent owner preliminary response coming. Limitation, you cannot include any new testimony evidence, so any new expert declarations. You can, however, use and refer to testimonial evidence that is already in existence as a result of other proceedings. You can't amend your claims in a patent owner preliminary response. What can you do? You can present claim construction arguments. You can show that the petitioner is barred or stopped by application of all those rather mind-numbing real party and interest, time bar, and privy issues that we were talking about. You can attack the prior art status of art that the petition relies on. You can argue the merits. You can argue that X piece of prior art does not, in fact, anticipate the claims because it's lacking X, Y, and or Z limitations. And you can argue against joinder. So you can do lots of things with these, but you just cannot amend your claims, and you cannot create and include new testimony evidence. This article that I cite to here is just a quick summary of some pros and cons, reasons why patent owners have elected to or have elected not to file these patent owner preliminary responses. Obviously, if you can prevent institution, this is your last chance to prevent institution, because once the proceeding is instituted, as we're going to discuss, you can't appeal that decision to institute until it's over. So this is the last chance to prevent institution. Get the last word, say something in opposition to the petition before the board decides whether to institute. Get rid of the arguments and art that aren't very compelling, and actually, again, try to prevent institution, get out early. Some reasons why you might not file one if you're a patent owner. Maybe you want to let the proceeding be instituted and get to a final written decision and trigger these estoppels so that you don't have to confront these same arguments and art in litigation or a subsequent USPTO challenge. You can buy yourself some time, again, by filing a patent owner preliminary, or by not filing a patent owner preliminary response. You obviously are not expending your resources on that, and you can get to work on your actual patent owner response. Keep your powder dry, keep the element of surprise, don't show your arguments on claim construction or otherwise, and obviously just to save some money. Next topic, decision on institution. Just I think one slide on this. The decision on institution, the statute says that the determination whether to institute shall be final and non-appealable. And as you can see from this slide, the courts, first 3 cites are from the Federal Circuit, last cite is from the Eastern District of Virginia. These are all recent decisions. The 3 Federal Circuit decisions, I think, were issued on the same day in late April. Basically ruling that statute means what it says, that a decision by the board to institute a post-grant or inter partes review, or a decision by the board not to institute a post-grant review or inter partes review, those are not immediately reviewable. And furthermore, the sort of alternative avenue of attack of bringing a collateral action invoking the Administrative Procedure Act to challenge a decision denying institution, not a viable alternative. Claim amendments. Fourth topic, claim amendments. There's a very limited opportunity for the patent owner to amend. We already knew before the PTAB started issuing decisions, and this comes out of the rules, that the patent owner has the right to file only one motion. And notice that even an amendment has to proceed by way of motion, although the patent owner does have the right to file that motion after it has conferred with the board. And there's only a right to file one such motion presenting new or amended claims. The amendments must respond to a ground of unpatentability involved in the proceeding. So you can't just make any amendments you want to make. You have to be solving the problem that exists for you as a result of the specific challenge in the proceeding. The Patent Office says that the presumption will be that you can only basically substitute one claim for a canceled claim. So a one-for-one substitution, you're not going to get away with canceling one claim and adding 24 new claims. And as we're going to see that, there's no guarantee you're going to get to substitute any claims. Any additional motion is only permissible upon the joint request of both the petitioner and the patent owner, and then only if the petitioner and patent owner jointly show that the additional amendment will materially advance settlement. You cannot broaden the scope of claims, and of course, just like in any other post-grant situation, amendments will trigger intervening rights. Furthermore, patent owners are stopped from recovering subject matter in these proceedings that has been disclaimed in any other proceeding. So that the road is a difficult one for patent owners seeking to amend claims. Then it got harder because in January of this year, the board issued this decision in idle free, which has become rather notorious because it imposed such significant additional restrictions on patent owners seeking to amend claims in these proceedings. The patent owner bears the burden of proving the general patentability over the prior art of the proposed amended claims. So, first of all, the patent owner bears the burden, not the petitioner. So that's an important thing to note. Furthermore, what does the patent owner have to prove? The patent owner has to prove by a preponderance of the evidence that the proposed amended or substitute claim is patentable over the prior art in general, not just over the prior art that's at issue in the proceeding. Furthermore, the patent owner must describe the level of skill in the art, and by that the board means the skills and ordinary creativity of one of ordinary skill in the art. I mean, that's part of the patent owner's burden. And the board said that basically, if the patent owner does not include that in their motion to amend, the motion will be denied. And again, the patent owner has to distinguish not just the prior art of record, but all of the prior art that it knows of. So quite significant. The this idle-free decision was, this actually case here that I'm citing actually predates idle-free, but it gives some illustration of what we're talking about here, and I thought it was helpful language to include. The board in this case, this Avaya case from decision from last July, said that, consider this, if a feature Z is proposed to be added to a claim to render it patently distinct from the prior art, it would be essential for the patent owner to establish the significance of feature Z from the perspective of the level of ordinary skill in the art. It is not enough to state only that no prior art teaches or suggests, a claim including feature Z. And this is important to note because it's that kind of argument that can succeed in ex parte prosecution. It will not succeed, at least not under the very strict standards that the board has imposed. Instead, the board says, if you want to amend your claims in these proceedings, you need to indicate whether feature Z was known in any context. And if so, explain why that context is irrelevant, so remote or different from the claimed invention that one of ordinary skill in the art would not have applied that teaching to arrive at the claimed invention. So you have to talk about this additional feature and what is known about it in any art. You have to explain why one with ordinary skill in the art at issue would not have adapted relevant basic or general techniques that are taught in textbooks in the field of the invention to the particular use required by the claimed invention. And as if that weren't enough, you, the patent owner, has to do all this in 15 pages. You have to present your claims, the amended claims, and all of your arguments in 15 pages of double-spaced 14-point font text. You have to list every amended claim in the body of that 15 pages, and you have to show support in the original disclosure of the patent for each claim that is added or amended. Very, very difficult to get claims amended. But it has happened. I believe it has only happened once, and it happened on May 20th of this year. The first successful motion to amend in a PTAB contested proceeding occurred. However, so I refer you to this case, this decision by the PTAB, because it perhaps gives some guidance as to what it will take to get claims amended in these proceedings, at least the way the board is proceeding so far. It is worth noting that the patent owner only responded to the petition, didn't file any other response to the petition other than its motion to amend. So it basically immediately conceded that amendment was necessary, that its motion to amend was unopposed by the petitioner, and it basically said, I want to cancel claims 1 to 26 and substitute new claims 27 to 45, so that 1-for-1 substitution rule was followed, or guideline was followed. And even then, the PTAB didn't wholesale grant the petition. It actually denied the petition as to claim 45. New independent claim 27, which was the only new independent claim, it limited the claimed method, which was a method of repelling insects, and it limited it to 5 previously included compounds. So it narrowed the genus of claimed compounds useful in the method down to 5 specific compounds. It also, the patent owner's motion identified the cited reference as the closest prior art. So it agreed with the petitioner and with the board. This reference that we need to worry about is the closest prior art. That reference doesn't disclose or suggest the 5 recited compounds. Furthermore, the motion included an expert declaration and several publications showing the level of skill and the unexpected significance of minor structural changes. So the patent owner had a lot of evidence. Some commentators have indicated that this decision may not be quite as worthwhile as guidance. It may not signal that the floodgates are going to open and motions will now be granted. The case is a little bit unusual, and in that, for example, it was an unopposed motion. And furthermore, commentator Brett Thompson has suggested that maybe this kind of motion would only succeed where the art is unpredictable, because that was a key aspect of the patent owner showing that the art was unpredictable, and therefore, made the argument that obviousness should be interpreted more strictly. All right, at this point, we're going to pause, and for those of you who have signed up for CLE credit, I'm going to provide you with the code for CLE purposes. The code is the word indemnity, INDEMNITY. The word indemnity is the code for CLE purposes. Okay, just to finish up here in the last few minutes that we have, I wanted to highlight a few, I think, really interesting developments that are worth watching. We had a decision by the Federal Circuit recently, and this decision was actually in an inter-parties re-examination, but obviously the same principle would apply here, which is that a non-competitor watchdog type patent challenger, such parties do have standing to bring these post-grant proceedings in the Patent Office, to bring inter-parties review, to bring post-grant review, not CBMs, because CBMs have that standing requirement. You actually have to have been sued or charged with infringement. But that standing requirement does not apply to IPRs and to non-CBM PGRs, as it were. And so those people can bring these challenges in the Patent Office. That's the good news. The bad news is if they don't like the Patent Office's decision, they lack standing under Article 3 of the Constitution to pursue a Federal Circuit appeal. Not a terribly surprising decision, but one that will limit the potency of, a little bit anyway, the potency of these proceedings for non-competitor watchdog type challengers. This is an interesting decision. This just came out on July 23rd. We'll see how this holds up. The PTAB has held, in this case, this Z-Tech versus Westinghouse Electric, that it has the discretion to deny a petition without even considering its merits. And it's worth taking a look at, I think. Basically, the board here said, we're not going to, address the merits of the petition because you, petitioner, just didn't comply with our rules. You have to, under our rules, include a full statement of the reasons for the relief requested, including a detailed explanation of the significance of the evidence, and where each element of each challenge claim is found in the prior art patents. So you have to, basically do this mapping between the prior art and the claim language. And you didn't do that. Instead, you, petitioner, included numerous grounds and underdeveloped assertions which would place a significant burden on the board and contravene the efficient administration of the office, and place a significant and unfair burden, furthermore, on the patent owner to respond adequately. And just to give you a flavor of the kind of thing that the petition did, that the board said was so far out of bounds, we don't even have to consider this petition on the merits, is you presented no fewer than 127 asserted grounds of unpatentability, and this was the kind of language in the petition, that the claims are unpatentable basically in view of, quote, any of, reference A, reference B, reference C, et al., or reference D, et al., in view of reference E, et al., and on and on and on. And the board said that kind of language really is 8 separate grounds, and it's just a big mess. So we'll see again whether this kind of decision by the board, but it was a rather extraordinary decision, I guess, on an extraordinary petition. The Eastern District of Virginia got upset with both, Judge Davis in the Eastern District of Virginia got upset with both the counsel for the patent owner and counsel for the petitioner in a concurrent litigation recently because neither counsel disclosed to the court that the defendant had filed IPR petitions on the patent in suit. And all this was overlapping at the time when the court was considering and reconsidering summary judgment motions on invalidity. So at the time the court was considering whether to grant summary judgment of invalidity to the patent challenger in the district court, the court said it would have been really nice to know that these same patents in suit were being challenged in IPR petitions, and a pox on both your houses, petitioner and patent owner, for not telling the court. The court said a patent infringement suit with an invalidity counterclaim and an IPR proceeding involving the validity of the same patent claims fit into that category of related matters requiring notification to the respective adjudicative tribunals under both counsel's general duty of candor and good faith to the court, as well as, in this case, Virginia Ethics Rule 3.3 requiring candor toward the tribunal. And the court said it mattered because the court could have considered on its own motion whether to stay the district court proceedings, and it was concerned about the defendant challengers having, in effect, two bites at the validity apple. So I guess an important safety tip, if you're involved in one of these, make sure that you, whether you're the patent owner or the petitioner, that you notify the district court in any concurrent co-pending litigation. Finally, it's worth noting that the Patent Office has recently held several roundtables all around the country inviting comments from counsel and parties with regard to how is the board doing in these post-grant contested proceedings. And it is now, following up on those roundtables, it has issued in late June a Federal Register notice seeking public comment on all aspects of the new administrative trial proceeding. So it's very much openly inviting criticism, critique, suggestions for improvement now that we've had about 18 months of experience with these proceedings, actually closing in on 2 years of experience. It particularly noted, and again, it's a Federal Register notice worth taking a look at because you can see the kind of questions that the USPTO is seeking comment on, but things like, should we continue to apply the broadest reasonable interpretation claim construction standard to unexpired patents in these proceedings? Should we change the practice on motions to amend, that very onerous amendment practice? Should we change the rules to allow patent owners to present new testimonial evidence in patent owner preliminary responses? Should we allow patent owners to get in discovery in these proceedings the petitioner's evidence that might refute its obviousness challenge? Should we change the rules regarding patent owner challenges to real party and interest status? Should we change the additional discovery business? Should we have different rules for coordinating multiple both contested and ex parte post-grant proceedings? What circumstances should justify extending that 1 year period to issue a determination that I said was for good cause, an additional 6 months? And should we allow live testimony in the oral hearing before the board, or otherwise change the format of the board hearings? I would note that the board recently did grant a request to allow live testimony before the board, so it has happened. But I would note that it was particularly perhaps unusual circumstances where the board said, I think it was the inventor, it was a situation where I think the patent owner was basically trying to antedate some prior art under the old first to invent system, and the board regarded the inventor's live testimony as critical to its determination on the inventor's credibility. Comments are due on September 16th of 2014, so there's still time to weigh in with regard to this notice. And, I think we can expect that the rules and the board practices might well be amended in some or all of these areas as a result of the public's participation. And that's all I have. And so it's my understanding we don't have any questions we are at or even past 1 o'clock. And so I'll wrap up on behalf of all of us here at the College of Law. And thank you for your participation once again in our webcast.